Thank you very much, everybody, for joining us this morning, where we're going to be talking about the slightly thorny problem of proximate cause and its impact when considering policy exclusions. For those of you who don't know us already, my name is Neil Howes, and I'm a partner here at Reeve. I'm based in the firm's National Insurance Disputes team, and Leeds is my office. And speaking with me today is going to be Sophie Briggs. Sophie is one of our principal associates. Again, she's part of our National Insurance Disputes team, and she's based in Norwich. Today's talk is all about proximate cause. But what is it, and why is it important? Sophie.
Thanks, Neil. So the starting point under any policy of insurance is that unless the policy provides otherwise, the insurer is liable for losses which are proximately caused by an insured peril or harm under the policy. So conversely, the insurer is not generally liable for any loss which is not proximately caused by an insured peril. And those basic principles are enshrined in Section 55 of the Marine Insurance Act 1906, but they also apply equally to non-marine insurance. So rather unhelpfully, the Act doesn't define what proximately caused actually means, and the courts have grappled over the years about exactly how to define it. So the best way of looking at it is this. The proximate cause of the loss is not necessarily the last cause in time. Instead, it's the cause which is proximate in its efficiency. In other words, the dominant, effective, or operative cause. So, way back in 1918, a ship carrying gold from Southampton to Le Havre was torpedoed by a German U-boat. It limped into port, where it was ordered by the harbour master to be berthed at sea, where she later sank in the rough seas. In that case, the House of Lords dismissed the argument that the peril closest in time, being berthed at sea, would always be the proximate cause. And that led to the conclusion that the torpedo attack was the proximate cause of the ship's cargo having been lost at sea. So when you're looking at proximate cause, the starting point to ask yourself is what is the dominant, effective, or operative cause of the loss claimed? And is that cause an insured peril under the policy? So it sounds simple, but in life, things are rarely straightforward. And that's because in most cases, there tends to be a complex chain of interlinked events which have led to the loss and therefore multiple possible proximate causes. To complicate matters further, some of those causes might be insured whilst others are not. Some of those causes might be subject to express policy exclusions, and some policies, for example, BI policies, only cover for losses caused by composite perils, which may require the insured to demonstrate that the loss claimed has been caused by more than one insured peril in a specified sequence of events. So it's a bit of a minefield. Neil, is there any principles to apply?
Thank you, Sophie. I think when it comes to proximate cause, there are probably 5 basic principles that it's worth bearing in mind. So the first principle, principle 1, is something that we've touched upon already. In other words, the proximate cause, it could be the most recent causal event in the chain, which leads to the loss being suffered, but that's not always the case. So timing isn't the overriding factor. The second principle to bear in mind, and although it sounds like a bit of a contradiction in terms, is that there may be more than one proximate cause. In other words, there could be more than one dominant, effective, or operative cause of the loss which is claimed in the policy. So to give you an example, in a relatively recent case between the University of Exeter and Allianz, an unexploded World War II bomb was uncovered during construction works that were being undertaken near to the insured's building. And that meant that a controlled detonation had to take place, caused damage to the insured's building, and also business interruption. The case ended up eventually in the Court of Appeal, who had to decide whether the proximate cause of the loss suffered by the insured was the dropping of the bomb or its detonation nearly 80 years later. And the Court of Appeal decided in that case that even if the dropping of the bomb was not the proximate cause, it was certainly a concurrent proximate cause of loss, and consequently that a war exclusion in the policy excluded cover. And that brings us rather neatly onto our third basic principle, which is this, is that where there are concurrent proximate causes of roughly equal efficiency, and then you've got one cause which is covered by the policy, but the other is excluded, then the exclusion prevents recovery under the policy. Now, that's sometimes known as the Wayne tank principle, and it gets its name from a case way back in 1974 following a fire at, of all things, a plasticine factory. And in that case, the claimant firm of engineers sought to make a claim under their public liability policy. And there were two causes of the fire. Firstly was the claimant supply and install of what the court described as a useless and dangerous piping material called Durapipe, and that was then wrapped in heating tape. And then secondly, the decision by one of the claimant's employees to leave the heating tape on overnight when the installation hadn't actually been properly tested. So in that case, the Court of Appeal confirmed that even if those two things could be classed as two dominant causes of roughly equal efficiency, the fact that one of them, in other words, the unsuitable nature of one of the products supplied, was excluded from cover, meant that the insured was able to make a recovery under the policy. Conversely, though, you have principle 4, which is that in contrast, where you've got concurrent proximate causes of harm, and one is covered by the policy and the other's not expressly excluded, then the policy will generally respond. So to give you an example, back in 1980, a boat named the Miss JJ suffered fairly severe damage whilst crossing the channel, and the boat's owners sought to claim against their marine insurers for the cost of repair of damage. That case also ended up in the Court of Appeal, which concluded that there were two concurrent proximate causes of the damage. First was the fact that the boat had been poorly designed and constructed, and the second was the rough seas which the boat ran into, and apparently the waves it started hitting were over the size of a house. The conclusion reached by the Court of Appeal was that the insurer was required to pay out under the policy in circumstances where one of the proximate causes, in other words, the impact of the rough seas, was covered, and the other, the vehicle's poor design and construction, was a peril that wasn't expressly excluded. And that approach was adopted by the Supreme Court when it was deciding the kind of FCA test cases, which examined various proximate cause issues in the context of claims for COVID-related losses, if you remember, in relation to business interruption policies. In that case, the Supreme Court took the view that each of, incident, outbreak of COVID-19 within a particular radius of a policyholder's premises was sufficient to satisfy the proximate cause test, even though there were multiple, and in this case, probably millions, of similar uninsured but unexcluded events. And then finally, when you talk about basic principles, it's worth bearing in mind principle 5, which is this, that the insured has the benefit of proving, to the usual civil standard, the loss claimed was proximately caused by an insured peril under the policy. But if the insurer wishes to rely on an exclusion of the policy, then it's the insurer that has the burden of proving to the court that the exclusion applies. So in most cases, the insured also has to demonstrate that but for the insured peril, the loss claimed by the policyholder wouldn't have occurred. But as illustrated by the Supreme Court's decision in the FCA test case, there are occasionally cases where a strict application of the but-for test might be slightly contrary to common sense, and the court is prepared to take a fairly pragmatic approach. So, Sophie, having covered some basic principles, which policies do they tend to apply to?
So in short, pretty much all types of policies, as you can see on the slide, property damage policies, marine policies, business interruption policies, public liability policies, the list goes on and on. The principles also apply to professional indemnity policies. So, for example, a standard PI policy for a design and build contractor will typically include cover for liabilities caused by design or specification-related errors, but will exclude cover for liabilities caused by workmanship issues. So, in other words, liability is incurred because the insured has simply constructed something badly. And that tends to be known as a design versus workmanship exclusion. So that doesn't mean that liability for defects or heads of loss caused by both design and workmanship issues will always be excluded from cover when a claim is brought against the design and build contractor. Much of it will depend on the precise wording of the policy and whether proximate cause of the defect or head of loss claimed can be classed as poor design or poor workmanship. However, what it does mean is that where poor design and poor workmanship are pretty much equally to blame, then the exclusion is likely to apply. And that can sometimes cause significant issues between PII insurers and design and build contractors during the course of a claim, because for obvious reasons, the contractor will want to be covered for as much of the claim as possible, and it may not be clear, particularly in the early stages, whether the proximate cause was design or workmanship or a mixture of both. So in most cases, expert evidence is needed in order to get to the bottom of those issues. And in some cases, insurers may decide that they need to commission their own expert evidence in addition to any that's being obtained on the insured's behalf for the purposes of defending the claim. So what's important is that both insurers and the insured need to know where they stand in advance of trial or any mediation help with the claimant, so that if the insured is being asked to make a financial contribution towards any settlement or award, then they're prepared for that. One way that some insurers are seeking to avoid some of these coverage issues is to include a proportionality loss clause in policy wording, which in simple terms says that if a liability or loss is caused by both an insured and an excluded risk, then the insurer will indemnify the insured for the proportion of the liability or loss caused by the insured risk based on a fair and equitable allocation of the respective causes of the liability or the loss. So, for example, if it's determined that a defect or a head of loss is attributable 30% to design failures and 70% to workmanship issues, then insurers cover 30% of the resulting liability. These clauses provide a degree of clarity for both parties, but then there's still potentially issues between insurers and the insured about apportionment, which still needs to be determined.
So on a separate note, then, do the basic principles we've talked about, do they always apply?
No. So every case turns on the wording of the policy and the facts of the case. So, for example, a policy which uses the words caused directly or indirectly instead of simply caused by or occasioned by in an insuring clause may enable the insured to show a looser causal connection than the standard approximate cause test. But then the inclusion of words caused directly or indirectly in an exclusion clause may extend the scope of that exclusion. So, Neil, would you say that the law on proximate cause is now settled?
I think for the moment, the answer to that is probably yes. But the current law on proximate causes is not without some fairly vocal critics. I think one of the criticisms that's commonly made of the law as it stands is that it can potentially lead to some quite odd results, particularly in situations where you may have so-called mirroring exclusion clauses in two policies that might otherwise cover the loss. So, for example, in theory, you could have a case where physical damage to a third party's property has been caused by both negligent workmanship and negligent design on the part of a contractor in roughly equal measure. So a public liability might normally cover loss caused by negligent workmanship in that situation, but expressly exclude negligent design. Conversely, you've got a professional indemnity policy, which would usually cover negligent design, but it would expressly exclude poor workmanship. And as a result, and on a strict application of the weighing tank principle we've been talking about, the insured could be left without cover. Now, various commentators have suggested ways in which the law might evolve to cover off that particular type of situation. One way would be for the courts to deal with this type of issue in the same way that liability was determined in the Fairchild and Glenhaven funeral services case. And that's a case that concerns the assessment of liability for mesothelioma cases. And the House of Lords, as it was then, effectively abandoned the standard rules of causation and held that in mesothelioma cases, the claimant should be able to recover damages in circumstances where it was able to establish that one or more insured defendants must have been responsible for the cause of the cancer, but it was simply unable to prove exactly which one. There are also reported cases in Australia where the court seems to have started to move perhaps slightly away from a very strict interpretation of weighing tank and to decide cases on a much more fact-specific basis. And I think it probably could be argued that the Supreme Court was prepared to, shall we say, flex the rules on some elements of proximate cause test to a certain extent in the FCA test case it decided in relation to COVID-19 and business interruption. All of that said, the House of Lords in Glenhaven, for example, made it clear that its approach in that case was very much unique to mesothelioma cases. It would, in my view, be a massive leap, of course, to take that similar broad brush approach in more general cases where proximate cause and exclusions are an issue. So for now then, I think the law on proximate cause is fairly settled and probably unlikely to change in the near future. So Sophie, kind of bringing all of this together then, what are the key things that people need to be thinking about if they've got a case on where proximate cause could be an issue in relation to cover?
So there's a few things to be thinking about. Firstly, you need to consider whether the loss claimed under the policy might have more than one cause. The next question is going to be to assess what is the likely proximate cause of the loss. In other words, what's the dominant, effective, or operative cause of the loss claimed? And is that an insured peril under the policy? If there might be more than one proximate cause, and those proximate causes are of roughly equal efficiency, is one of those causes expressly excluded under the policy? And if the answer to that is no, then the loss is likely to be covered. If the answer is yes, then the loss is likely to be excluded. Now, none of that might be straightforward. So if the answer isn't obvious, the key question to ask yourself is what further information, including expert evidence, might you need in order to investigate the position and really reach a decision? And if you're an insurer and you think that the exclusions might apply, it's also important for you to reserve rights early to allow you to make a call about what the proximate loss is and how that impacts on the cover that should be provided under the terms of your policy.
Thank you very much, Sophie. Well, as you know, everybody, Cover Talk's very much intended to be a kind of bite-sized session about insurance law, but it looks to me as though we probably do have a couple of minutes for questions. So, Harriet, have we got any questions that people have perhaps?
Yes, I think we can just fit in one or two. So the first question I'd like you to consider is this. What's the rationale of cover or for cover not applying if one proximate cause is covered when another is excluded versus the situation where one proximate cause is covered and the other isn't expressly excluded? They seem to result in two very different outcomes.
You're absolutely right. I think they can result in very different outcomes. I think the rationale for this is that all of these proximate cause cases are decided on the wording of the policy, and the court is trying to get to the bottom of the presumed intention of parties in terms of what was intended to be covered and what wasn't. And I think that's the rationale for the distinction. In other words, in one set of circumstances, you've got something that insurers have expressly said that they will not cover. And then in the other type of situation, you've got a situation where effectively the policy is silent. And I think it's that distinction between insurers specifically saying we are not covering this and insurers being silent on the point, which leads to the very kind of different outcomes.
It's interesting, isn't it? Because the whole aspect has an element of subjectivity about it, and the bench is viewed generally to the facts they're facing at the time. I mean, you mentioned that the precise wording of the policy is very important, and we're always told to look at it in the first instance. But can you give us an example why that's so?
Yes. So I've talked very briefly about the Supreme Court's test case in relation to COVID-19. The Supreme Court made it clear in that case that there is very much a presumption that insurers are only liable for losses proximately caused by a peril covered by the policy. But that can be displaced depending on the wording of the policy. And it's that wording of the policy that becomes really critical. And that's what the court is going to focus in on. So there was a relatively recent case called Brian Layton against Allianz. That was an owner of a garage where there had been a fuel leak from a pipe, and that caused contamination. And insurers then sought to rely upon a pollution and contamination exclusion clause. And the court looked at the way that that clause had been drafted and took a fairly narrow view on what the scope of it was, and in the end decided that the insured was entitled to cover based on the wording of the exclusion. I think the opposite is also true. So I know that one of my colleagues, Andrew Tobin, down in our London team, acted for a reinsurance case that came to trial earlier this year called Hamilton against Afghan Global Insurance, and I think a company called Annam. That was a case where a warehouse had been effectively lost by the insured during the Taliban's takeover of Afghanistan following the US withdrawal in 2021. And part of the case, in terms of the reinsurance, revolved around the wording of an exclusion, which said that the policy excluded any losses caused directly and indirectly by seizure. And so because the words directly and indirectly were included within the policy, one of the rationales for holding in reinsurers' favour was that that was sufficiently broad to exclude the insured's claim, even if seizure wasn't necessarily the proximate cause. So I think hopefully those two cases in themselves can seek to demonstrate just how important it is, the wording in each case as to how that might affect the outcome.
Yes, I can see that entirely. And I can also say that at this juncture, I understand that there's going to be an embellishment and a further presentation on that Hamilton case in our next cover talk next month. But other than that, I'm afraid we don't have any more time to go through any more questions. So may I pass the baton back to you, Neil, to close up?
Indeed. Well, thank you very much for joining us, everybody. We really enjoy doing these sessions. So if you wouldn't mind, as you kind of log off, there should be a feedback form that pops up. So please give us your feedback. And we also love it when people suggest topics that they'd like us to do cover talks on in future. As Harriet says, we'll be back with another cover talk next month. We'll be circulating the invite for that shortly. But in the meantime, thank you very much for joining us and have a great day.